I'm going to provide some really important insights and information on estate planning. The information I will be sharing is not common knowledge, and I think many people would not be aware of it unless they have consulted with an estate planning attorney. Estate planning sets up how you want your wealth to pass on to your children or to other people after you die. And today, I'm going to explain how this would work in the case of joint ownership of property, referred to as joint tenants with rights of survivorship or joint with rights of survivorship. There's joint ownership most often when a married couple owns property jointly. And this seems like a fine idea, especially if both of you contributed towards and acquired the property together, or the property belonged to one of you prior to the marriage, but now you want to share the wealth with your spouse and show them that you love and trust them. The biggest advantage to having property in a joint account when it comes to estate planning is that if one of you were to die, this is the simplest, quickest, and the cheapest way to transfer title to someone else. So if the husband were to die, the grieving wife doesn't need to worry about looking for documents, finding a lawyer, going to court, etc. The law automatically transfers the title to her, and she would now own the property. This would be immediate. She can avoid probate, and in many cases, there will be very little or no costs or expenses associated with this transfer. But there are risks involved such that many estate planning attorneys will adamantly advise their clients against putting the spouse's name down as a joint owner on the client's property or assets. I think this is more of a concern nowadays with so many people getting divorced and remarried and a large number of families being blended families. And the most effective way I can illustrate the risks will be through some examples. So let's say you set up your assets to be under joint ownership with your wife. You guys have two biological children together, and you wrote a will instructing the division of your property such that if you were to pass away, 50% of it would go to your wife and 25% to each of your two children. And then you get into a car accident and pass away. What would happen to your property? Does it get divided up as you had indicated in your will? The answer is no. As soon as you die, all of it becomes your wife's property, and she can do whatever she wants to do with it. The laws are such that joint property is passed according to the property's titling and not according to the will. In other words, title to assets overrides the will. No matter what your will says, the surviving joint owner will get all of the property. Let's say your wife happens to be a second wife, and there are two children between the two of you, but one of them happens to be a son from your previous marriage, and the other is a daughter from your wife's previous marriage. Obviously, you love your new wife, so you decide to put everything in a joint account with her. Let's say that your will before you met your wife, your new wife stated that upon your death, your son would inherit all your wealth. And let's say your wife's will stated that her daughter would inherit all her wealth. You and your wife get into a car accident where both of you die, except you die at the scene of the accident and your wife dies 15 minutes later in the ambulance. Who do you think would inherit the property that was jointly owned by the two of you after both of you are dead? The answer is her daughter. Her daughter will get it all. Now you could be rolling in your grave because your son got nothing and her daughter got everything. Anyway, your son could say, my new stepsister took my inheritance away from me. But no, she didn't. The stepsister only got her rightful inheritance. It's just that the joint property became solely your wife's property when you died minutes before she did. And what the daughter inherited was just her mother's wealth after she passed away. So in this game of whose will counts, it's whoever coughs last that wins. If you don't want to leave anything to your stepchildren, you don't have to do anything, because in our court system, stepchildren do not have inheritance rights. Only biological and adoptive children do. But if you want to leave your stepchildren with any part of your wealth, you need to name them in your estate plan. You must name them in your estate plan. You might say, well, I'm going to make sure that both of our wills, my wife's and my will, say the same thing, and that the property gets split evenly between our children after my wife and I pass away. Okay, after you die and your wife becomes the sole owner of all your assets, is there any possibility that she will go and change her will? You'll say, well, she promised me that my son will inherit some of our property and she's an honest woman. What if she has a falling out with your son? Do you think there is any chance that she will go and change her will after you're dead? The point is that if it's really important to you that you leave some of your wealth to your children, then you should not put someone else's name on your assets as a joint account holder, where there's a possibility that they can either inadvertently or intentionally divert your assets to other people and leave nothing to your children. When folks realize these risks, some people want to go and put the property back in their name only. But that's going to be really hard to do. There are ways, there are a couple of ways, such as having her sign the postnuptial agreement, which is a contract that can override the law for transfer of title. Some people will say, I really want to provide for my wife or my husband and make sure that they are well taken care of financially after I pass away. There's a way to do that other than through a joint account. You can create a life estate in your will for her, where the property goes to her for the rest of her life and she can derive all the benefits from it while she's living, but after she's dead, after she dies, your will controls the property. Anyway, this is all I have to share for now. Bye!